To my melanated family and spiritually conscious brothers and sisters around the world. I am Brother Tommy. And it is time to get it in. One Love Family. This video discusses the book In the Matter of Color. Race and the American Legal Process During the Colonial Period by Leon Higginbottom. Why of all of the multitudinous groups of people in this country, do you have to single out Negroes and give them this separate treatment? Oral argument before the United States Supreme Court by Thurgood Marshall, then Chief Counsel for the plaintiffs in Brown v. Board of Education. At approximately 7:17 p.m., April 4, 1968, an assassin fired a shot mortally wounding Martin Luther King. Late that evening I received a call from the President, Lyndon Johnson, who had appointed me 4 years earlier to the United States District Court, asking me to come to the White House early the next morning to discuss with others who were being called the national significance of Dr. King's death. Though the President acted quickly in collecting his counselors for a meeting the next morning, another section of the nation would not wait the night to express its own response to this national tragedy. 10 blocks from the White House, buildings in the largely black ghettos of Washington, D.C., were already in flames. As the painful night lingered on, news reports indicated that more and more people had taken to the streets, many striking out irrationally and in anger, in city after city, in response to the senseless death of the prophet of nonviolence. President Johnson opened the meeting at the White House the next morning with the question, "What can we do now?" There were many thoughtful responses. Some talked of strengthening civil rights legislation, others spoke of further improving manpower programs, still others argued for additional condemnations of racism. The idea for appointing yet another presidential commission was also introduced. Although the discussion was calm and dispassionate, a deep sense of shared pain was apparent. Most of us had known Dr. King intimately and had worked with him in the attempt to obliterate racism from American life. As I listened and reflected on the various suggestions made from such thoughtful and well-meaning people, I kept thinking of the question Thurgood Marshall had asked the Supreme Court 13 years earlier. Why, he had asked, multitudinous groups of people in this country, do you have to single out Negroes and give them this separate treatment? That morning sitting in the White House, I knew there was an indisputable nexus between the dark shadow of repression under which, historically most American blacks have lived and the rioting occurring within 10 blocks of the White House. Why, I thought to myself, in the land of the free and the home of the brave, had even brave blacks so often failed to get free? Why had that very legal process that had been devised to protect the rights of individuals against the will of the government and the whim of the majority been often employed so malevolently against blacks? What were the options that ought to have been exercised years ago, even centuries ago, to narrow those disparities and meted out justice that had periodically and had now once more kindled black hatred and white fear? In the company of the great lawyers present at the President's meeting, Supreme Court Associate Justice Thurgood Marshall and Attorney General Ramsey Clark, as well as the other notable government and public officials, Cabinet Officer Robert C. Weaver, civil rights leaders Roy Wilkins, Whitney Young, Clarence Mitchell, Reverend Leon Sullivan, and Vice President Humphrey, it was inevitable that I would ponder how the legal process contributed to this malaise. For in 1968, in this nation's 192nd year, things could have been different. If the legal process had been racially just, the nation in the 1960s would not have been torn asunder as it was by the unrelenting demands by blacks for dignity and equal justice under the law, pulling against the stubborn resistance of those who had been conditioned to believe in the status quo as the ultimate expression of liberty and justice for all. The institutionalized injustice of racial apartness had first brought Martin Luther King to the forefront and now, ultimately, had brought him to his death. Particularly during this bicentennial era, it is appropriate to assess the interrelationship of race and the American legal process. This nation has just celebrated its 200th birthday in a most grandiose fashion. Conventions have been held in almost every town reaffirm those self-evident truths, and the oratory will continue to 1987. The 200th anniversary of the United States Constitution. As praise is heaped on the great leaders of yesterday, and as some laud 1776 as the golden era of liberty, it is often suggested that if only today's leaders had the integrity and character of Jefferson, Franklin, John Adams, Washington, and Madison, today's racial difficulties might be quickly resolved. Few have had the temerity to contradict this general but misdirected consensus, for it is bad bicentennial form to refer to the fact that many of America's founding fathers owned slaves and that most, either directly or indirectly, profited from the evil institution that enslaved black human beings only. The bicentennial drum roll of revolutionary heroes and events, then, symbolizes one thing to white Americans but quite another to blacks. From a predominantly white perspective, the Declaration of Independence is viewed as former President Nixon described it, the greatest achievement in the history of man. We are the beneficiaries of that achievement. But who, until recently, did we describe? Not Black America. Frederick Douglass, a leading abolitionist who was born a slave, described Independence Day in 1852 from the perspective of blacks and slaves rather than whites and slaveholders. This 4th of July is yours, not mine. You may rejoice, I must mourn. To drag a man in fetters to the grand illuminated temple of liberty, and call upon him to join you in joyous anthems, were inhuman mockery and sacrilegious irony. Say it with a sad sense of the disparity between us. I am not included within the pale of this glorious anniversary. The blessings in which you, this day, rejoice, are not enjoyed in common. The rich inheritance of justice, liberty, prosperity and independence, bequeathed by your fathers, is shared by you, not by me. The sunlight that brought light and healing to you, has brought stripes and death to me. Likewise, from a predominantly white perspective, the pledges of the preamble to the Constitution honestly set out the largest principles for which the new American legal process would strive. We the people, in order to form a more perfect union, establish justice, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. From a black perspective, however, the Constitution's references to justice, welfare, and liberty were mocked by the treatment meted out daily to blacks from the 17th to 19th centuries through the courts, in legislative statutes, and in those provisions of the Constitution that sanctioned slavery for the majority of black Americans and allowed disparate treatment for those few blacks legally free. Further, whatever opening there might have been for one day peacefully redefining we the people to include, as it should have in the first place, black Americans, was abruptly closed with the 1857 U.S. Supreme Court decision Dred Scott v. Sanford. When asked if the phrase "we the people" included black people and whether blacks were embraced in the egalitarian language of the Declaration of Independence, Chief Justice Roger Taney, speaking for the majority, wrote, "At the time of the Declaration of Independence, and when the Constitution of the United States was framed and adopted, blacks had no rights which the white man was bound to respect." In effect, Taney had not answered the question. Rather, he had gone back in time in an attempt to determine what the Founding Fathers had intended, and in so doing, had argued from the untenable position that the Constitution might never be any larger than the restrictive vision of 18th century America. Thus, for black Americans today, the children of all the hundreds of Kunta Kints unjustly chained in bondage, the early failure of the nation's founders and their constitutional heirs to share the legacy of freedom with black Americans is at least one factor in America's perpetual racial tensions. 20 years after the Civil War, over 100 years after the Declaration of Independence, 250 years after the first black man set foot in America, in Huckleberry Finn, Mark Twain, in a parody of white attitudes, suggested that as late as 1884 many white Americans still failed to perceive blacks as human beings. He writes, "Good gracious. Anybody hurt? No one. Killed a nigger? Well, it's lucky because sometimes people do get hurt." This book will treat from a legal standpoint this historically persistent failure of perception. What should have been on the minds of all in power during the 17th and 18th centuries was the question James Otis raised in his provocative paper of 1764. Does it follow that 'tis right to enslave a man because he is black? Specifically, this book will document the vacillation of the courts, the state legislatures, and even honest public servants in trying to decide whether blacks were people, and if so, whether they were a species apart from white humans, the difference justifying separate and different treatment. I am aware that an analysis of cases, statutes, and legal edicts does not tell the whole story as to why and how this sordid legal tradition managed to establish itself. Nevertheless, there is merit in abolitionist William Goodell's statement, "No people were ever yet found who were better than their laws, though many have been known to be worse." While I recognize that a view of slavery from the perspective of the law does not make a complete picture, I join in the conclusions of Winthrop D. Jordan when writing on the colonial period and C. Vaughan Woodward when writing on the Reconstruction period. Jordan has advised us, while statutes usually speak falsely as to actual behavior, they afford probably the best single means of ascertaining what a society thinks behavior ought to be, They sweep up the felt necessities of the day and indirectly expound the social norm of the legislators. And C. Von Woodward has stated, I am convinced that law has a special importance in the history of segregation, more importance than some sociologists would allow, and that the emphasis on legal history is justified. While I do not represent what I put forward here as a complete picture of the practices of the society, that canvas will never be painted unless someone first treats adequately the interrelationship of race in the American legal process. Obviously, there were several factors that contributed to the inclination of the legal process to treat blacks so differently from all others. Many have written in great detail on some of these factors. For instance, in so many legal decisions, there was the powerful presence of the economics of slavery. The key question for many a righteous and learned community leader was whether it was cheaper to have blacks as slaves or to have blacks as free labor. Or, possibly, instead of black slaves, would it have been cheaper to have had white indentured servants or white free labor? The issue of safety and the natural fear of slave revolts was also intertwined in the chain of legal judgments. While never reluctant to protect and maximize their property rights in the slaves, many judges and legislators were reluctant to recognize that slaves had, in their own right, any basic human rights. Many feared that any judicial protection of the slave would trigger further challenges to the legitimacy of the dehumanized status of blacks and slaves. Since the plantations were often in isolated settings and there was an ever-threatening possibility that the slaves might rise up and slay their oppressors, any judge whose decision criticized racial injustice might be accused of weakening the master-slave system. For instance, in a famous North Carolina decision State v. Mann involving the issue of whether or not it was a criminal offense to subject a slave woman to a cruel and unreasonable battery, the court stated that a slave was to labor upon a principle of natural duty, to disregard his own personal happiness, and that the purpose of the legal system was to convince each slave that he had no will of his own, and that he must surrender his will in implicit obedience to that of another. Such obedience is the consequence only of uncontrolled authority over the body. There is nothing else that can operate to produce the effect. The power of the master must be absolute to render the submission of the slave perfect. The court emphasized that for the slave there is no remedy, that we cannot allow the right of the master to be brought into discussion in the courts of justice. The slave, to remain a slave, must be made sensible that there is no appeal from his master, that his power is in no instance usurped, but is conferred by the laws of man at least, if not by the law of God. The court noted that this unlimited dominion is essential to the value of slaves as property, and to the security of the master, and the public tranquility. The control the court sought was the total submission of blacks. It had incorporated into its law-made morality the psychological conceptions Frederick Douglass subsequently described. Beat and cuff the slave, keep him hungry and spiritless, and he will follow the chain of his master like a dog, but feed and clothe him well, work him moderately and surround him with physical comfort, and dreams of freedom will intrude. You may hurl a man so low beneath the level of his kind, that he loses all just ideas of his natural position, but elevate him a little, and the clear conception of rights rises to life and power, and leads him onward. With only slightly less paranoia, white society feared that slaves and free blacks would form an alliance with either indentured servants or poor whites to topple the plantation aristocracy, which exploited both blacks and poor whites. As the percentage of blacks, slave or free, increased, the probability of successful rebellions and revolts became greater. Thus, in examining degrees of repression, one can almost correlate a rise in the black population with an increased level of legal repression. In terms of moral and religious issues, there was the underlying question of whether or not America had the right to treat differently and more malevolently people whose skins were darker. From this perspective, it became necessary to determine whether blacks were part of the human family and whether, after they had adopted your religion, they were then entitled to be treated as equals, or at least less harshly. In a nation under God, the moral or religious rationale that justified or rejected the institution of slavery had to have been an important factor. But what tortuous moral or religious rationale had to have been devised for a religious people to have tolerated treating black human beings more like horses or dogs than white human beings? Finally, there was always the issue of whether or not blacks were inherently inferior to whites. If blacks could be perceived as inferior, basically uneducable and inherently venal, it might be intellectually less self-condemnatory to relegate them because of their lower status to a subordinate role, either for their good or, as one judge had the audacity to express it, for the good of the total society, whites and blacks alike. Thus it was that even the man many Americans see as one of the major forces for liberty and equality, Thomas Jefferson, found blacks to be inferior to whites in the endowments both of body and mind. After comparing the characteristics of the three major races in America, white, black, and red, Jefferson concluded that although the condition of slavery imposed great misery on blacks, the inferiority of the black race was caused by more than mere environmental factors. The improvement of the blacks in body and mind, in the first instance of their mixture with the whites, has been observed by everyone, and proves that their inferiority is not the effect merely of their condition of life. This unfortunate difference of color, and perhaps of faculty, is a powerful obstacle to the emancipation of these people. Yet even during the 17th and 18th centuries, there were voices that challenged the morality and legality of slavery. In our chapters on Pennsylvania and the Declaration of Independence we note the moral antecedents to the Declaration of Independence. As early as February 1688 the Germantown Mennonites of Philadelphia had issued a proclamation against slavery, having found it inconsistent with Christian principles. In our chapter on the English experience we deal in detail with the Somerset case as a contrast to the American counterpart sanctioning domestic slavery. Lane 1772, 4 years prior to our Declaration of Independence and 15 years prior to the Constitution, Lord Mansfield, Chief Justice of the King's Bench, said that the state of slavery is of such nature that it is incapable of being introduced on any reasons moral or political. It is so odious that nothing can be suffered to support it, but positive law. And with that statement, Lord Mansfield freed the slave, Somerset, demonstrating that there was no universal view on slavery among the civilized nations of the world. As we survey in this volume legislative and judicial doctrines, it will be difficult to isolate one and only one factor as the sole explanation for the legislated, adjudicated, and upheld racial deprivation that gained the official approval of the American legal establishment. As in most things, the causal factors were multifaceted. On some occasions the economic concerns seemed the dominating influence, while in other instances a moral or religious aspect appeared to be more significant. But however tightly woven into the history of their country is the legalization of black suppression, many Americans still find it too traumatic to study the true story of racism as it has existed under their rule of law. For many, the primary conclusion of the National Commission on Civil Disorders is still too painful to hear. What white Americans have never fully understood but what the Negro can never forget is that white society is deeply implicated in the ghetto. White institutions created it, white institutions maintain it, and white society condones it. Since the language of the law shields one's consciousness from direct involvement with the stark plight of its victims, the human tragedy of the slavery system does not surface from the mere reading of cases, statutes, and constitutional provisions. Rather it takes skeptical reading of most of the early cases and statutes to avoid having one's surprise and anger dulled by the casualness with which the legal process dealt with human beings who happened to be slaves. Generally neither the courts nor the legislature seem to have been any more sensitive about commercial transactions involving slaves than they were about sales of corn, lumber, horses or dogs. This casualness is reflected in a perfectly legal and acceptable advertisement of that era. 120 Negroes for sale. The subscriber has just arrived from Petersburg, Virginia, with 120 likely young Negroes of both sexes and every description, which he offers for sale on the most reasonable terms. The lot now on hand consists of plowboys, several likely and well-qualified house servants of both sexes, several women and children, small girls suitable for nurses, and several small boys without their mothers. Planters and traders are earnestly requested to give the subscriber a call previously to making purchases elsewhere, as he is enabled to sell as cheap or cheaper than can be sold by any other person in the trade. Hamburg, South Carolina, Benjamin Davis. The advertisement of Benjamin Davis was not unique, it was typical of thousands of advertisements posted in newspapers and bulletin boards throughout our land. In the New Orleans Bee an advertisement noted, "Negroes for sale. Negro woman, 24 years of age, and her 2 children, one 8 and the other 3 years old. Said Negroes will be sold separately or together, as desired. The woman is a good seamstress. She will be sold low for cash, or exchange for groceries. For terms apply to Matthew Bliss and Company, 1 front levy." How could a legal system encourage and sanction such cruelty that permitted the sale, as Benjamin Davis bragged, of several small boys without their mothers? Was there any justice in legal process that permitted a mother, 24 years of age, to be sold in exchange for groceries and separated from her children, only 8 and 3 years old? Looking past the commercial facade, one sees the advertisement as stating that American laws encourage the destruction of black families and the selling of human beings. The only criterion was the demand of the marketplace. In our chapters on Georgia and South Carolina, for example, we cite several statutes that offered rewards to bounty hunters bringing in the scalp and ears of runaway slaves. These statutes, subtly cast in the language of lawyers, can make one oblivious to the fact that the lives of human beings were involved. From one perspective, it appears that these two legislatures were merely defining penalties and granting rewards just as they would do upon the recovery of an individual's lost property or as a reward for the slaying of a bear or wild coyote. Yet the scalps and the ears referred to in the Georgian and South Carolina statutes were not those of wild animals. They were not those of murderers or traitors. They were the scalps and ears of human beings, persons who had committed no crime other than that of seeking that same freedom the colonists declared to be the birthright of all whites. As I reflect on these statutes, I think of my experience as youngster 40 years ago viewing the local cowboy and Indian movies. The bad guys, the Indians, naturally would occasionally scalp some white adult. Always as my friends and I left the movies, we were angry because of the cruelty the Indians had inflicted on those innocent pioneers, who were merely traveling over Indian land. Thus, it was a matter of astonishment to learn as an adult that the legislatures of Georgia, South Carolina and many of the other colonies actually legalized acts as inhumane as those dreamt up by movie producers. Perhaps the movies were fictionalized accounts representing Hollywood screenwriters' vivid imagination. But the colonial statutes were not bits of fiction. They were the reality of the colonial legal process, a process that rewarded those who were willing to scalp and cut off the ears of blacks who dared to seek freedom. While we recognize today how inhumane and how immoral this legal process was, it seems that Americans would rather distort their history than face the extraordinary brutality to which these advertisements attest and the inadequacy of a system of laws that promoted and sanctioned such brutality. The legal process has never been devoid of values, preferences, or policy positions. By the very nature of its pronouncements, when the legal process establishes a right of one particular person, group, or institution, it simultaneously imposes a restraint on those whose preferences impinge on the right established. Ultimately, the legal process has always acted as an expression of social control. Professor Wilhelm Aubert has argued that beneath the veneer of consensus on legal principles, a struggle of interest is going on, and the law is seen as a weapon in the hands of those who possess the power to use it for their own ends. The mechanisms of control through judicial decisions and statutes span the sanctioning of slavery and the special limitations imposed on free blacks, to the prohibitions against interracial marriage and sexual activity, to the eliminating of the legal significance of blacks' conversions to Christianity, to generally restricting any activities or aspirations of blacks that might threaten the groups in control. The law is usually perceived as a normative system, founded on a society's custom and convention. Charles Warren, one of the most distinguished scholars on the history of the Supreme Court, observed, "The court is not an organism dissociated from the conditions and history of the times in which it exists. It does not formulate and deliver its opinions in a legal vacuum. Its judges are not abstract and impersonal oracles, but are men whose views are necessarily, though by no conscious intent, affected by inheritance, education, and environment and by the impact of history past and present." Oliver Wendell Holmes shared this perception. The life of the law has not been logic, it has been experience. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. In treating the first 200 years of black presence in America, this book will demonstrate how the entire legal apparatus was used by those with the power to do so to establish a solid legal tradition for the absolute enslavement of blacks. It will be an effort to look at this history primarily through the special focus of a legal lens, to examine the pathology of the law, its creation, its sanctioning, its tolerance, and its occasional eradication of the racist practices that caused one group of human beings to receive such special, harsh, and disparate treatment. Though this book focuses on only 6 colonies: Virginia, Massachusetts, New York, South Carolina, Georgia, and Pennsylvania, I believe these 6 provide representative examples of the range of arguments and methods by which laws and judicial decisions specifically governing blacks developed, and by which slavery became entrenched in North American colonies. To be sure, historians can unerringly point to some differences within the colonies not studied here. Nevertheless, I am confident that these 6 are fair examples of the whole spectrum. Some might suggest that when probing any pattern of man's inhumanity to man, the proper place to start ought to be at the beginning of human history. Be that as it may, A special lesson lies in tracing and trying to understand exactly how the American legal process was able to set its conscience aside and, by pragmatic toadying to economic needs, rationalize a regression of human rights for blacks. Most interesting will be to see if we can discover how it came to do so during the very period it was displaying such compassion, courage, and even genius in extending and reinforcing as never before the freedom of whites. We might then better understand what many blacks see so clearly: a direct lineage of contemptuous law from the wasteland centuries of slavery, through the 100 years of false equality since the Emancipation Proclamation, to the confrontation street politics of the 60s. Having taught classes on race and the American legal process for several years to students of history and students of law, I can predict that many will find this book painful and that some, defensively, will ask, why hasn't he spent as much time on the positive aspects of the American colonial period, a period during which the rights of mankind may have been advanced more than during any other period in history of comparable length? My answer to this question is first, that the positive aspects of our colonial tradition have been examined and justly praised. In fact, it may very well be that it was particularly to avoid tarnishing the aura of egalitarianism surrounding the birth of our nation that the negative aspects of this period have been so long ignored. I further recognize that many enduring strengths in the American constitutional and legal process came out of this very colonial period I now criticize, and that it was these strengths that 19th-century black Americans eventually relied upon in their legal struggle for their own liberty. Second, that the history of the American colonial period is incomplete and dishonest without an examination of its dark side. I write not to encourage racial polarity, anger, or hatred, but instead to heighten our consciousness so that we, both blacks and whites, will understand how the law has contributed to perpetuating villainy on millions of Americans, solely because of their darker color. Thanks for tuning in to the Melanated Roots channel. Please like the video and subscribe to the channel. Until the next video. Peace.